Thank you, Chairman Casey, and thank you again for staying. And I ate 2 cookies on the way up so I could have try to keep up with Mark Fischel's energy from the last session. So we'll see how I do. But you've heard from some fantastic practitioners today who do regularly appear before us representing different sides. And I think that's a great experience. What Jim and I wanted to do, and Jim is our Chief Administrative Law Judge, we wanted to give you quick summaries of some cases that we heard that we believe adds to the administrative jurisprudence of the board. And what I mean by that is there are some nuances in these cases which have either reinforced or added to, or in some cases changed, things that you need to know when you come and you do a case before us. And of course, Jim and I, we love to work together, and here's us reading some briefs and discussing them in Latin. No, we don't really speak Latin, and we actually do get very many good briefs. So we do read what is written by your lawyers, in some cases by you, and we appreciate those things. The first thing I want to talk about today is settlements. Those of you who have bargaining units and grievance procedures, you're probably no stranger to settlements. What a lot of folks don't know is that you can settle appeals before they go to hearing. And in fact, you can even settle appeals before a report and recommendation comes out after the hearing occurs. And sometimes with discipline, you don't even have to do that. You don't even have to wait for the filing of the appeal. Sometimes there's a part of the statute that talks about last chance agreements. So certain disciplinary cases can actually be settled pre-appeal. So those are some things. Our board recently, a few years ago, did a case called Caesar versus Franklin County Board of DD, and this was at a time when the County Board of DD was switching over their workshops, privatizing them basically. And the plaintiff appellant was an employee who could not pass a drug test for legitimate medical reasons, but she was going to have to drive a bus or a van in her new position. She employed competent counsel. She was very sure, based upon her doctor telling her that she would be able to pass this test after she was weaned off certain medication for which she had a prescription for. She needed that in order to obtain the operator's license so that she could drive that van. She thought she gave herself plenty of time. And the settlement was executed with a contingency for being able to have that ability to drive. Guess what? Didn't happen. The attorney for the appellant did try to file under a theory of mistake in contract law and try to get the settlement overturned. Of course, the board did not do that, and I very much agree with them. You know, it was a plan for a contingency, and she had knowledge of what could happen. And so she got the benefit of her bargain. That case did not go to an appeals court for appeal. I don't think they would have fared any better there. But settlements stick. So be careful how you write them. And when you put contingencies in, realize that you're going to have to stick to that. The other case, is anyone from Tuscarawas County here? Any Tuskies? Okay, tell me who that man is, please. Yeah, that's Mayor Homey. That's right. That's right. Mayor Homrickhausen. He actually has a trial coming up in September. There was an indictment against him where he allegedly was pocketing personally from performing marriages in his official capacity as mayor. That's one of the things you can do is marry people. Jim, can we marry people? We can't marry people, can we?
Not legally.
Yeah, because we're not justices of the peace. But yeah, you know, administrative law. But anyway, yeah, he did that supposedly, allegedly. He has not been convicted. However, there is a procedure in our system where someone who's indicted can be suspended from their elective office, and that's what happened. Well, guess what happened? City Council and Mayor Homey were not getting along, and they thought Mayor Homey was not performing up to par, so they initiated an investigation. And they interviewed 3 employees. And the mayor fired those employees the next day after they participated in the investigation. This was a very odd case because I usually do not have appointing authorities coming to me and saying, oh yeah, we did it, we're bad, we just want to settle the case. Can we do this? And I'm like, well, sure, you can settle your case if you want to. You both have competent counsel. Send me a settlement agreement. I'll send it to the board, and the board can construe it as a withdrawal. Well, Mayor decided, since he was the appointing authority, he didn't think that the city had the power to enter into a settlement agreement. And where we are with this now is he did file a motion. He filed a motion for intervention. I did grant that before the hearing stage and gave him time to submit an affidavit with evidence to say why the settlement shouldn't go forward. He declined but wanted an extension. I did not give him that extension because I thought it drew things out and it drew out liability for the city. So I received the settlement agreement, which was signed by its duly authorized officers, sent it to the board approved it. The settlement was construed as a withdrawal of the appeals of the 3 employees. And so what the Tuscarawas County Court has said is, hey, Mr. Mayor, while you're suspended from your office, you do not have any standing to challenge a settlement made by your city, which you did not like. Apparently, he didn't like these 3 employees for whatever reason, or he thought that the settlement included language that was derogatory to him or whatever. So we'll see what Tuscarawas County Court of Common Pleas does if the mayor is exonerated. If he's found not guilty, he'll be returned to office, and they say at that point he'll have standing to at least argue his appeal. If he's convicted, it won't matter, but it's a case to watch because settlements are an important way for parties to come to a final conclusion of a matter without the length that's involved in extensive litigation. So we'll watch. I hadn't heard him called that before, but I love it. So we'll watch and see what happens with that case. The next thing that I want to tell you about is certifications of record. If you come before us and have a hearing, I'll make a digital recording of that hearing, or Jim will if you're before him, or Jeanette, or Robert. Once we're done with that digital recording, it goes into our file, and when an employee appellant or an appointed authority appellee, if they disagree with the board's final order, they have a right to appeal that to a court of common pleas. It's our job as SPBR to include a transcript of that digital recording and also any of the documents, evidence that was admitted at hearing to go with that to the common pleas court. Well, in another interesting Tuscarawas County case, our friend, the Chief Public Defender, Gerald Latanich, who has an objection with SPBR. There he is. Gerald is objecting. And Gerald hired Jonathan Downs, and Downs made an argument that, that this statute, 11912, should be strictly construed no matter what. And what that meant was, since SPBR gave over the second day of the recording transcript shortly after it filed the first day of the transcript, and even though Mr. Latanich had a full transcript of the second already in his possession, they took it to the 5th District Court of Appeals. And wouldn't you know it, the 5th District Court of Appeals located in Stark County, almost surprisingly to me, said, well, yep, that statute says you got to get it all there and you got to get it all there at once. It can't come in pieces. And the bottom line is that they disaffirmed SPBR's final order. Mind you, the woman who was the appellant had been removed, and her discipline was modified to a 10-day suspension. And so the court basically threw out her modification on a technicality. That case has since gone to the Ohio Supreme Court, and oral argument was heard on May 25th, and we're still awaiting a decision. And of course, if I know my lawyers in here probably remember in law school, the plain meaning rule, you interpret statutes according to their ordinary meaning in plain language unless it produces an absurd result. So one of the issues here is equal protection. Can a case be thrown out because of a technicality on when a certain piece of evidence was due, even though it affects the substantive rights of the claimant? So in other words, we don't know what's going to happen yet, but it's a case to watch. We'll see what the Ohio Supreme Court does. I didn't check it this morning. I hope that if there's any like super smart Westlaw Lexis folks, it's Gowdy versus Tuscarawas County Public Defender, 2022 AA-04-0191, and then the Supreme Court case has a different number. But if you look it up and you find out that they delivered the decision today, and I didn't know about it, well, hey, more power to you. But anyway, that's something to watch. The next thing that I want to talk about is RC 416713. Again, these are all cases that came before us. They're all real people, all real appellants, all things that this board decided. 416713 is the piece of the statute that is the anti-retaliation provision for reporting workplace safety hazards. We actually get quite a few of these cases. We call them OSHA appeals, but technically they are people who have filed a complaint with the Public Employees Risk Reduction Program or told their supervisor, hey, I don't want to work in this unsafe environment, or they contacted someone at their employer or otherwise, and then they suffered an adverse action as a result. Or at least that's what the appellant is trying to prove in those cases. There's 4 cases. Jim's going to talk about one of them in a minute. This is a unique case, Mackey versus Buckeye. There's a missing E there. That's my fault. It's not Bucky. It's Buckeye, local school district. And relatively new superintendent at the time, but they had a substitute bus driver. And the substitute bus driver was, I'll just say, I got the impression that the board felt she was quite pesky because it was during COVID. She knew a lot, an extraordinary amount for a layperson, especially a bus driver, about MSDS, material safety data sheets, knew a lot about PERP regulations and OSHA regulations. She complained that the sanitizer they were using on the buses was not properly labeled, and she was absolutely right. Her supervisor took it took it very trivially. They're like, yeah, you know, whatever, we got all this going on right now. We're just using some alcohol to wipe down the buses. Don't worry about it. You know what's in it. Didn't take the complaint seriously. So she goes one better and she takes it to the school board. And she says, you're in violation. You're doing this, this, and that. And the school board chairwoman gave her a nice dressing down and what was tantamount to a written reprimand. You don't go to the school board. You need to work with your supervisors, da, 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 da. Now, of course, I found that to be a very important piece of evidence because she did have a right to complain. And when she didn't get her problem adjusted with her supervisor, she definitely had to write. In fact, she could report it to the board from the get-go, regardless of whatever Neola policies. Those policies are great because they help you write a policy, but unless you adjust them to the current law, I mean, you get what you get. You can't just download the handbook and make it your handbook without a little bit of legal consultation on the side. So that was one of those. It was a boilerplate policy that says you can't report. You got to follow the chain of command, right? It's a school district. Follow the chain of command, though, almost like we were working in the military or something. After she got that little dressing down, undeterred, she went on the school bus one morning because she was a mom, had 3 kids in the district. She goes on the school bus to talk to her friend, who's another bus driver, and they were eating some Egg McMuffins together, and she was complaining about how the district wasn't doing anything, and he's like, oh yeah, they're bad, and so and whatnot. And so somehow the school district finds this out because they see her. And in the meantime, she decides to call the Department of Agriculture and has an inspector, because the Ohio Department of Agriculture regulates pesticides. Hand sanitizer is a pesticide. I didn't know that. See, I learned a lot from these cases. So the ag inspector comes in, unexpected, uninvited. She's not even at this point working that day. He goes in there and mulls around the bus garage. I'm telling you, this district was up in arms over what she was doing. Like I said, I think they were very irritated. At the end of the day, they said, we're never going to hire you as a permanent employee, and we don't want you as a substitute anymore. Goodbye. And by the way, we know you talked to one of our permanent bus drivers and was trying to egg him up about this issue about the hand sanitizer. So they ended up disciplining that permanent bus driver because instead of wiping down his seats, he was talking about hand sanitizer and whether it should have an MSDS. That case never was disciplined. There was never any unfair labor practice or anything filed over that. He took his discipline and moved on with life. She filed the appeal. And in the middle of it, she got a pretty good lawyer, and he argued the case. And the board did a special remedy, something that we don't usually do. What do you do with an employee who's casual, who doesn't have a right to a particular number of hours? And all she really lost was a tentative prospective ability to substitute bus drive on certain days. And so we came up with a remedy which was more or less, hey, for the next year, you need to offer her substitute opportunities commensurate with what she did in the previous year. And for your first available permanent position, you either need to hire her or show that the other applicant was demonstrably superior. Now, I don't know if she's gotten a job there, or if she's moved on, or whether she is driving truck. I mean, she drove semis and all kinds of things, so she was a very multi-talented person. But employers, the big takeaway from this is employees don't lose protection under the statute just because they may be very annoying, okay? Don't let your emotions get in the way of people's rights. So the next one I have was another guy who I think just thoroughly annoyed his employer. You can see it with the witnesses on the stand. Mr. Chikoulas, and this is, the theme here is balancing of rights. This board engages in a lot of balancing of rights. So we had Mr. Chikoulas, who goes to work one day in one of our fine northeastern Ohio cities in a suburb of Cleveland, and they tell him that we're going to dig up a water pipe and there's a big trench. And if any of you are in construction, you know, or civil engineering, you know that if you dig up dirt and it's not virgin dirt, you better have something in there to protect the workers from a trench collapse. Well, this particular pipe had been dug up many times. And he is there on the scene, supposed to be supervising the laborers working in the trench. And he has his van parked there. And there's an operator who belongs to a different union. The operator is the guy with the big backhoe, right? Well, for some reason or another in good old Cuyahoga County, the operator seems to not be in the chain of command to our appellant, Mr. Chikoulas, so he can do whatever he wants and decide not to use the trench box. And he decided not to use the trench box. So what does Mr. Chikoulas do? Well, he reports it promptly and invites someone out from the Public Employees Reduction Program, Risk Reduction Program from Columbus, Ohio. Invites the inspector from Ohio, BWC. He's more than happy to come on up to northeastern Ohio, and he goes and makes a video of the violation as it was happening. Oh, Cuyahoga County was not pleased. And so they fired Mr. Chikoulas because, gosh darn, Mr. Chikoulas received training on how to place traffic cones when you stop your public vehicle in a roadway. And gosh darn it, he did not put those cones up. And you know what? If you don't have those safety cones up, you know, I mean, it can cause an accident. I mean, this is just general. I mean, it's real. He violated it. He was wrong. He should have put the cone up. So the question becomes, do they really fire him because he didn't put the cone up, or do they really fire him because the perp guy came out? And so the board engages in some balancing, and you know, the kind of the takeaway is, well, Mr. Chikoulas did get his job back. But the import is that even if an employee commits some comparative fault or has some comparative fault in a matter or some misconduct, it doesn't mean, like, I don't know, back in law school, we used to learn about contributory fault in the 19th century. You know, like where if you were riding your horse and wagon and the wheel fell off, but you didn't have you weren't holding both straps at the same time, you didn't recover anything against the wheel company that made a mistake because you were also at fault. Those days are gone, long gone. So even though our gentleman appellant here had a little bit of comparative fault in the matter, he did commit his own safety violation. That did not mean that he lost protection under the Act for other things that he reported. And then next, Jim, I'm going to have you come up and talk about Mr. Nicholas Bomsky, if you would.
All right, Randy, thank you. All right. Following up Mark Fischel, it's a two-edged sword. It's kind of like, it's great to have Mark here. He's a super lawyer, but it's sort of like, following the Beatles is the last act of the night. Let's talk about this case. Hey, Ray, what do you think would happen if you've got a first responder, a firefighter, and he legitimately reports some safety issues with turnout equipment and fire suppression equipment, but it also turned out that he committed several material misrepresentations on his employment application?
I don't know, Jim. Tell us what happened.
I'm glad you asked, Ray. Okay, well, in this case, Nicholas Bomsky versus Hanover Township Fire Department, our appellant, Mr. Bomsky, was a firefighter. He did actually meet his prima facie burden under the OSHA statute, 4167.13. He did report various violations to the Public Employment Risk Reduction Program, as Ray indicated. They did come out. This was prior to, actually, the township knowing about it. The township discovered in Mr. Bomsky's past some things during the dependency, actually, of the case at SPBR. He was out on administrative leave. It turned out Mr. Bomsky worked for a prior township fire department, and during that time he'd engaged in some bar fights and drunkenness and things like that, and he'd been terminated. Well, then he'd applied subsequently for the Hanover Township Fire Department. Well, of course, they had a clause in their employment application which says, well, you're not supposed to commit any material misrepresentations on your application. If you do, it's a fireable offense. It's pretty standard language, right? Well, Mr. Bomsky shaded a few things. He said that he'd worked for the previous township from 2011 through 2015. Well, it turned out he was fired in 2011. He also said that he left for other employment when it turned out he was fired because he had been convicted of a crime. At the same time, he was on probation for another crime, and those are the reasons he was fired. So the determination was, what do you do with this? So basically, we looked at it, and he didn't actually quite. He had been fired subsequent to his appeal at PBR, and he didn't file his second appeal or his last one. So, but nonetheless, the question is, well, even if he had proved his prima facie case, and he'd gone on to prove that potentially the reason he was fired was because he reported a perp, does this other material misrepresentation impact on that? And I looked at it and I said, well, these misrepresentations were certainly fireable offenses. So what do? We can't really put this guy back because he's committed these material misrepresentations. There's also a clause in the basically the position description which says there's an ethical conduct code that needs to be followed, and everybody has to behave accordingly. And lying on your application because you had been convicted of some crimes and some other things didn't appear to comport with that. So basically I had recommended to the board, and the board agreed that he shouldn't be put back under these circumstances. It turned out there really wasn't a remedy available anyway, but the takeaway is if 4167.13 isn't a complete panacea, it won't protect you if you've committed really egregious acts where you probably wouldn't have been able to be employed at that institution or department anyway. So in that case, what the board ended up doing was saying that his prior bad acts basically prohibited his continuing employment with the township, and the cases were dismissed.
Thank you, Joe.
All righty.
So our final case concerning OSHA appeals, or people who participate in the Public Employment Risk Reduction Program or file a report about a safety hazard, involves a fine university, Bowling Green State University, and some gas pipes, which of course in big plants, big facilities, a lot of times they'll use natural gas. This was a very interesting case because there was certainly some misconduct on the part of the university administration, considering that, again, they kind of thought that Mr. Lizzie was pesky because he was complaining about code violations for piping, and they didn't really want to deal with that issue. So he received a 3-day suspension He received a 3-day suspension because he left a gas pipe valve on when he should have put it off. Well, he filed his appeal trying to convince this board that the real reason for his 3-day suspension was because of his prior reporting of hazards and not because of his own misconduct. In my analysis of the case, I did determine that the university hadn't committed misconduct by targeting him for his report about the pipes, but also that his misconduct or negligence, if you will, by not turning off the gas pipe was also disciplinable. So the remedy was that the 3-day suspension, the board agreed, his 3-day suspension stayed on the books because I viewed that as commensurate with the error of failing to close off the valve, but also that the university be ordered to cease and desist from discouraging its employees to file reports of safety violations. And that wraps up that piece of it. So now we move to whistleblowing, and this is another example of the board's special jurisdiction. So for employees in the state of Ohio who file a written report, and it must be in writing, and that report specifies some violation of laws, rules, regulations, or a misuse of public resources, and it's sent to the right person, usually the person's supervisor, their appointing authority, in the case of a reasonable belief of a crime, a county prosecutor, the Ohio Inspector General, the list goes on. If you are interested in pleasure reading to try to bring on some drowsiness tonight when you go to sleep, I highly recommend 124.341. It's been a great statute for me. The first case we have was a little bit high profile. Again, some friends in northeastern Ohio, but not a Cleveland suburb, this time a Youngstown suburb, and Mahoning County Prosecutor's Office. Well, that is our prosecutor. And his name is Paul Geis. And then we have the guy who is actually, I'm one of those ID discovery junkies, so I, like watch those old cases or forensic files, things like that. This is Marty Desmond. So he's actually been on TV a couple times talking about murders in Mahoning County from like the 1980s. So I'm like, I know that guy. When he hit my hearing room, I'm like, I know that guy. Who are you? I'm like, oh yeah, you were on TV. In any case, Mr. Desmond claimed that Mr. Geis had some goings on in his office that violated a whole bunch of stuff, and whether that's true or not, or what exactly that was, isn't important to the takeaway of this case. But what is important in terms of SPBR case law is this case settled. And it settled on the eve after a federal judge denied Mr. Geis' motion to keep sealed certain grand jury testimony that had kind of sort of already been released. This doesn't come up a lot, but it took probably 2 years to resolve this, because at first SPBR did not give him a hearing at all. A prior administrative law judge had ruled that he did not meet the elements of a whistleblower report because he only made the report because his employer told him he had to. And at the time, we felt that the act of reporting should be voluntary. Not so, said the 7th District Court of Appeals. So if your employer does force you to report violations, it is still a good whistleblower report, even if they turn around and discriminate against you because you did what they said to do. So that's good law. That's an important takeaway. But also, I think this case settled for $500,000. But sometimes issues come up with collateral cases, including federal cases, and that can sometimes delay the hearing. The second whistleblower case I want to talk about is Janet Hageman versus Bryan City Schools. And the 10th District Court of Appeal, I think, changed a little bit of the jurisprudence concerning these whistleblower claims. Bryan City Schools went all out, hired lots of legal counsel. This case went all the way to the 10th District. They tried to get a hearing from the Ohio Supreme Court. They did not want to hear it. And ultimately, what the whole thing came down to is, what's your evidentiary burden to show that you were discriminated against because you filed a whistleblower report? Now get this. She was an assistant treasurer. She worked for a treasurer. The treasurer came into school one day bragging about how he just bought a computer for his daughter and didn't pay any sales tax on it. Now, those of you who may be teachers know that only teachers qualify for that sales tax exemption for computers they will use at home for school. Doesn't apply to treasurers. This woman, I think, was sincerely incensed by it, and she reported it to the auditor. Auditor didn't seem to care. Reported it to the school board. School board didn't want to do anything about it either. Reported it to the local sheriff. Sheriff, for some reason, took an interest in it. But it might have had to do with the fact that his kid played on a sports team for the school district, and there was some kerfuffle between board members and he. Not sure about that. In the end, Ms. Hageman was able to show that the district was motivated, and specifically the superintendent was motivated to discipline her because she wanted to please the treasurer, who did want to discipline her because she was making him very angry. The district tried to say that there was no crime and that Ms. Hageman could not have brought this complaint in good faith. One, because she waited a long time to report it to the, two, because obviously this is not a big deal, right? Well, it just so happened that it went to the Franklin County Court of Common Pleas, and the judge, I forget her name, but she was an ex-school board member at Westerville, and I think she might have even been a teacher, and she wrote right in there, no, it kind of is a deal. She didn't say it like that, much more lawyerly. But yeah, it was a potential offense, and it certainly wasn't the type of triviality that showed bad faith on the part of the appellant. So for those of you out there, what I think this case means, I think that but for is gone when it comes to whistleblower claims. But for is the claimant has to prove that the action would have been taken except for the report. And I think this case says, well, not so fast. The statute doesn't really say that, and it's more case by case. So beware. Okay. So then finally we come to off-duty speech, conduct, and social media. Now Mark did a fantastic job presenting you with the overview of this area of law. I just want to tell you about a few cases that actually came to this board recently and were adjudicated. And the first one is one that Jim's going to talk about.
All right. Well, obviously, one of Mark's takeaways from earlier in the social media presentation is that public employees have more protections regarding the First Amendment than may our compatriots in the private sector. But those protections obviously are not unlimited, and there are particular settings and circumstances in which they're more limited than others. As far as correctional employment, is one area where they're more limited because the government has a need to quell disturbance and promote order in an incarceration environment, obviously. In this case, our appellant was a lieutenant, a correctional lieutenant who worked for the Department of Rehabilitation and Corrections. He reposted 3 posts, all of which were controversial and, well, I found them to be offensive, and we'll go into that in a little bit. One of which it was basically said that it was if it's okay to fly a rainbow flag, it ought to be okay to fly the Confederate flag. Another one, well, that's one of the big ones. Okay, so one of his he had befriended or friended one of his coworkers who was out on disability, and she saw these posts and was highly offended. She was an African American, was in his zone, so she was his subordinate under certain circumstances. She sent several of these posts to another friend of hers who was not a Facebook friend of the appellant, but was also an African American, and she was quite offended as well, understandably. And she then sent an email and a complaint directly to the director of the Department of Rehabilitation and Correction, which, as you would imagine, got pretty fast action, which initiated the disciplinary process. So appellant was eventually removed. The person that I mentioned most recently, as far as that, the friend of the friend, also went to the appellant's basketball coach at the high school and mentioned the situation. And so they terminated his coaching contract for the year, although they said they were going to renew it for the next year. These posts or reposts are obviously objectionably offensive. I also found that DRC had a compelling interest in racial harmony, in that many of its staff and its offenders are of the African American community, and obviously several of the employees were sincerely and objectively offended by these reposts. However, unfortunately, this was during COVID. There was a lot of disruption at the institution as far as a lot of people were off on COVID, a lot of people were working extra. The warden was basically doing double duty at 2 institutions. So it was, there was some, I guess I'd say, administrative supervision that was sort of not as perfect as it could have been. So in that circumstance, there were a couple of things that we wanted to focus on. One was, well, basically viewpoint discrimination. And the first was that at about the same time all this was happening, the deputy warden decided that it would be a great idea to have a Juneteenth celebration. So the deputy warden sent a permission slip up the electronic chain to get a prison labor to make several posters, one of which had a clenched fist on it. This activity, now the inmate was not compelled to do this, he volunteered, but it was before permission was granted, and it was for a private organization. I found that the clenched fist has different representations to different people. Some people see it as sort of militancy and separation. Other people see it as a symbol of freedom and emancipation. So I also found that that is not a symbol that's universally associated with Juneteenth, which we generally see as a celebration of freedom. So that was problematic. She, of course, got no discipline, no counseling, no redirection, nothing. A second situation was a captain who was about the same as our lieutenant, 1 rank higher. And the captain had reposted some, let me make sure we get this right, basically had shared approvingly a post that described the hyperbolic hypothetical shooting of President Trump by President Biden, mocking President Trump's earlier statement about being able to shoot somebody and still get elected. And the captain also posted comments of calling President Obama detractors racist and indicating that President Trump was a racist. The captain received no discipline, no redirection, no counseling. So basically, in this environment, we have unequal treatment of speech, which can all be legitimately viewed as offensive. And in that situation, the board decided that these were mitigating factors because there was unequal treatment regarding speech that should have been seen as offensive. So that case is up on appeal to the Common Police Court currently. The takeaway is basically employees are liable for their political speech that causes a disturbance at work, especially in paramilitary organizations such as corrections, police, fire, National Guard, whether they intended to publish that speech or not. However, where the agency punishes disturbing speech unevenly, then the board may modify the discipline to ensure equal treatment of all concerned.
Thank you, Jim.
Right.
In our last case of the day, well, our second to last case of the day, and the one that deals with the issues that were just talked about, is Sagraves, and it's on appeal too. So it'll be interesting to see how it comes out for this appellant finally. I had actually recommended to uphold the termination in this case. The gentleman was a 5-year employee, stellar employee, great evaluations, well-liked, rapidly promoted to a lieutenant. But he worked in a prison that housed sex offenders, including pedophiles. And someone out there somewhere by the alias of Dan Man decided that he was going to report directly to the director of DRC about a post that an alias by the name of Graves posted. One of those posts dealt with, one of those posts dealt with the top symbol that you see, and that is supposedly a picture of a pedophile with a gun to their head and a caption that says, "Shoot your local pedophiles." And he had posted that, and it posted it to an alias called Graves, didn't hold himself out as a lieutenant for DRC, Department of Rehabilitation and Correction, but somebody figured it out. It's usually a friend of a friend. Somebody figured it out. He said he wanted to make a patch, a motorcycle patch. Okay, now keep in mind here, nexus, right? Connection. Where does he work? Department of Rehabilitation and Correction. What does he do? Supervises corrections officers. Who do those correction officers hold in custody? Pedophiles. Second thing he did, now how many of you know about the meme on the bottom? Very, very popular. Raise your hand. Come on, you see Smudge? Smudge the cat? Well, in this Smudge the cat meme, which is used over and over and over, he had posted the caption, and the women are yelling, "You used excessive force." Smudge says, "I carefully assisted the inmate to the floor." Okay? So Dan Man gets wind of these posts, sends it right off to DRC Central Office and says, "This man is supposed to be helping our families. Can he really do his job?" In other words, the display of his apparent attitude, and I do stress apparent, concerning excessive force and concerning the incarceration of pedophiles. I thought that for a 5-year employee that there is a strong enough nexus, a strong connection between the two, and at least one member of the public who is probably a family member of an incarcerated individual, that it impugned the integrity of DRC regarding its mission to rehabilitate sex offenders. The board disagreed with me and reinstated him, but not because of that, okay? And this is a play on Jim's case too. Disparate treatment matters. So when DRC makes a decision or any appointing authority in a vacuum, you must equitably enforce your rules. And our board made a little bit of law on this one, because for the first time, I think that I know of, they looked at DRC as one department, where traditionally under law, each prison is its own appointing authority. So the board has in the past deferred a little bit to the individual judgments of wardens because they run different prisons with different types of incarcerated individuals and have different needs and different classifications and different security levels. But this time the board looked at some other cases that were going on in other institutions. And they found that there were cases where people had made statements on the social media platforms, for example, to summarize, having to do with how they had no problem with their staff, but there's a lot of abuse that goes on, or a lot of staff fights and, kicking butt or whatnot. That was just one of the examples. But suffice to say, the board concluded that there were people in some other institutions that were getting no discipline for types of comments on social media that were parallelly offensive and would affect the public's view of DRC, even though they weren't the exact same cases. Takeaway, if you're going to have a social media policy and you're a big county or a big department, and you have satellite offices, don't think that you can tailor it dramatically by the institution. You need to treat your folks equitably across the board. With that, I'll take any questions that you have. It is time to go, and you can go, but Jim and I will stick around if you have a few minutes and you just want to ask us anything. We're happy to do that. We'll stay for as long as you want us to. Don't know if there's any other cookies outside, but folks, thank you for coming today. We loved having you, and we hope you enjoyed it.